Hi, everyone. Welcome to our Facebook Live broadcast. I'm Steve Altishan, Director of Client Partnerships here at Pacific Cascade Legal. And today we have attorney Darin Wisehart to talk with us about what goes into a Chapter 13 repayment plan and confirmation hearing. Hey, Darin, how you doing today?
I'm doing great. I'm ready for this topic.
I love it. I love it. This one is a little more complex than a Chapter 7. And so, you know, it's kind of one of those things where, you got to know what you're doing right off the bat. So we'll start with, can you just talk a little bit about the basic of what a Chapter 13 repayment plan is and what the confirmation hearing?
So the Chapter 13 repayment plan is the idea that you're making typically a normal monthly payment to the trustee. Every month you make it, and it's usually the same. Sometimes it bumps around depending on income and some other things. But when you come up with your plan payment, you have a certain set amount of time that you have to pay over that. And then you pay to the trustee. And the trustee's job is to take that money then and distribute it to the creditors. And this is very important, in accordance with the plan that you file. And this plan, this is your repayment plan. It kind of all goes together, but there's an actual plan that's a document that you file that tells the trustee what to do with the money and where the money is to go. And if you read that plan carefully, a lot of times it will outline where this money is going to go and who gets it first, who gets it second, and all the different lines. And that allows the trustee then to take that monthly payment that you have cordoned off and pay it out to the creditors as, pertaining to your plan and to the statute, of course, the bankruptcy laws.
Goofy question. Who drafts this plan? Who actually makes the plan?
The typical Chapter 13 plan is devised by the client, by the client or the client's attorney. Usually the client's attorney will create this, and they'll put it together, and they work together to come up with a number, A, that they have to pay. So there's two numbers here when we're creating this plan. What do you have to pay? And what can you pay? And both of those numbers play together when you're looking at this. But you'll work with your attorney and you'll really come up with a number, hopefully, that works. Sometimes you can't, and that's how Chapter 13 works. But the idea is to come up with a plan payment that's fair and should allow everybody to be paid throughout your Chapter 13.
Is there a set? I think you said 3 to 5 years. Is there a set time that you have to say I'm going to pay in this time, and then you have to stick with it?
Yeah, that's in Chapter 13 world. There's so many different opportunities, but what I'll stick to mostly is the typical ones. Okay, so of course there are the offshoot ones where you can do a lot of creative material with Chapter 13s, but usually, yes, you have a time period. If you qualify for Chapter 7, you can do a 3-year, a 36-month plan. Okay, and that's very important to know if you qualify for Chapter 7. If you don't qualify for Chapter 7, then you have to do 60 months, and that's your time period. Usually we address what the plan payment needs to be over that time. And sometimes for people who go 36 months, we choose to go longer because they're paying off a car, or they're catching up a house, or they're doing some typical things that you do in Chapter 13, where the plan payment would be too high if you don't spread it out a little bit, maybe add 10 months or 15 months, or even take it up to 60 months to allow you to repay and to do what you need to do in your Chapter 13.
So who looks at this then? Who actually reviews this plan?
Well, everybody should that has an interest in it, right? But the trustee is the big one. The trustee is the one that looks over everything, make sure everything's in order, make sure you're following the laws as you're supposed to, and make sure you're paying what you can and what you should and what you have to. So, of course, if you're not doing any of those things, then the trustee will give those items back to you in an objection and a motion to dismiss. And they'll say, you need to fix these things, or we're going to push to dismiss your case. And that's who's reviewing it. The creditors will review it as well, because if you're dealing with a creditor in your plan, then they want to make sure that their treatment is fair and their treatment is exactly what the statute allows for, or what the laws tell them that they get.
So if you disagree with the creditors, or disagree with the trustee. I mean, who makes the ultimate judgment that your plan actually is in accordance with what it should be?
And now you're talking about the gorilla in the room, right? So we're talking about the judge, the one that matters. The one that matters is the judge. Ultimately, they get the say in all of these things. They're going to read the statute. They're going to take a look at the case law. They're going to figure out whether or not you're going to win against one of these objections. And oftentimes, what I always tell people is trustee objections. They'll always outline why they object to that, and a good creditor objection, if they file it with the court, they'll tell you in a normal brief why they object and what their grounds are, and then you can see if you have something as far as pushing your own side of it, or if you need to negotiate it and find a middle ground or do something that allows it not to get to the judge, because if you're going to lose, of course, you don't want to go to the judge. But the judge is that ultimate gorilla. That's the one that really matters. And that's the one you want to sign off on this thing. When it's all said and done, the trustee will sign, the creditors will sign off, and the judge will sign off. And the judge's signature is the one that goes at the top of the order, right?
Yeah. So there's another thing in there that we mentioned at the beginning, this thing called a confirmation hearing. How does that fit into the repayment plan? What is that?
The confirmation hearing is the opportunity for the judge to call the case and then to hear whose objections need to be heard. Who said they have a problem with what's happening? Does the trustee have objections? Has the person made their normal monthly payments? Are they showing that they're committed to this process? And do creditors have remaining objections? And that's where the judge is evaluating, okay, where are we in this case? And do we need to set it out a few weeks or a month to give you time to resolve some of these things that need to be resolved? Or are we ready to say yay or nay? Are we ready to dismiss it now? Are we ready to have a hearing on the evidence? Maybe in certain cases you need to have an evidentiary hearing, and they need to set that. But the confirmation hearing is an opportunity to just call the case and have the judge just check in to see where everybody is. Are we making progress? Or are we just, feet in the concrete and we're not moving anywhere? Then maybe the judge can kind of jostle to figure out how to get the case moving, or it needs to dismiss.
Is a confirmation hearing required in every case?
Yes. Well, I'd have to review the statute to say, yay or nay on the exact black and white of it, but a confirmation hearing happens in just about every case. Yeah. The only times that in our district anyway, in the District of Oregon, we'll talk specifically about that one right now. The only times that a confirmation hearing does not happen is when there are no objections. And that's when you proposed a plan and no one has a problem with it and it's doing everything it's supposed to. Then the judge may review it in their own chambers and say, this plan looks good. It doesn't happen quite as often just because a lot of attorneys like to have that one confirmation hearing where you go and discuss, things that are remaining. But if there are no issues with the case, then why not just get it confirmed and have it signed off and done?
I like it. So kind of back to the repayment plan, there are different, I want to say, kind of ways you pay back creditors, kind of depending on who the creditors are, aren't there?
There's a lot of flexibility with Chapter 13. So it kind of depends on who needs to get paid first, who needs to get paid second. I always talk in terms of who has to be paid and how much can you pay. So we have two different numbers in Chapter 13, and we want to be sure we explain just on the short version what the Chapter 13 is going to have in your payment. One is the group that has to be paid. And the group that has to be paid are secured items that you're going to keep. So if you're going to keep a car, you're going to have to pay off the car. If you're going to keep your house and you're behind on your mortgage, then you get to catch that up. And those have to be paid in a Chapter 13. Also, a lot of tax debt will have to be paid depending on the years and some of the things. We can get really deep on taxes because they're not simple. Hardly ever are they straightforward. But some taxes will have to be paid in the bankruptcy. So those are called those typically I term them, what do you have to pay? And that's a group that's your basement. You cannot go lower than that, no matter what your income is. And sometimes I get clients that come back and I tell them, okay, your payment needs to be $500 a month because you have to pay these three things. and they say, well, I can't pay $500 a month. Well, that's where Chapter 13 sometimes will fail some people, because that's what you have to pay. You have to, you have to keep up with that. The second number is what can you pay? And this is based on your disposable income. So you've already got your basement of what do you have to pay. And then your second number is what can you pay? And if the what can you pay is higher, then you've got to pay a little more. And where that money then goes is to those unsecured creditors. It'll go to the credit cards, the personal loans, what I always deem the bottom, the last bucket to get paid. But your disposable income is supposed to go there. And if you get through the case, whatever's remaining, that's the trade-off. That debt goes away and you're able to move on with your life with the items that you need, like your car and paying off your taxes that need to get paid.
Can you redo a plan? I asked this a little bit before, but what happens if everyone agrees to it, it's confirmed, the plan is confirmed. That doesn't mean that the bankruptcy is over, right?
Correct.
And so,
go ahead. Sorry, Steve.
I was going to say, so if the plan is confirmed and you start paying, and something happens, you lose a job, but you get sick. I mean, can you reconfigure that repayment plan?
Yes, you can. Chapter 13 is flexible and it understands that 3 to 5 years is a long time for people. Okay, so the first thing we always say is you have the right to dismiss. So you can always dismiss your case. That's always something you can do throughout the case. You can always alter the case. A couple of questions we have to, as attorneys, we have to ask. One is, are you paying what do you have to pay? Because you've got to pay that by the end of the case. And so if you have say you're out of work for 3 months, you can dip your payment down for 3 months and file an amended plan to have a lower payment for a short period of time, 6 months, whatever it turns out to be. But then you have to bump your payment up more because you have to pay the amount that you're required to pay to get through the case. If your plan payment, though, has extra in it in the beginning that was developed for your disposable income, and your disposable income goes down, then you can lower your payment in accordance with that. You have to file an amended plan and you have to allow everybody to object, but you can definitely lower that disposable income number. You just can't lower the number that you have to pay. That doesn't get to lower unless you surrender something like a car and say, hey, I'm not going to pay on this car anymore. And then, yeah, your payment might be able to go lower than that. But these are things that, and this is why it's very important to have a bankruptcy attorney in your corner, because as you go through these things, different things happen and you need to know what your options are. And if you're representing yourself, you might not know what those options are. And sometimes you miss the opportunity to save some money here, or maybe you need to surrender a car that broke down or something like that. These are all things that happen in a case that have multiple paths to deal with them, but you need to understand what those options are for sure.
Is part of an attorney's job to sort of, I don't want to say keep up on it, but to help ensure that at least the debtor is keeping up on what's going on, so they may understand when they have to change. It feels like if there's no one like saying, okay, it's been 6 months, let's take a look at it or something.
And that is a very important thing for attorneys who are representing individuals to do. Every so often, you want to open the case. You want to make sure that they're on path, that they don't have things that are surprising. A lot of that stuff happens at confirmation. As an attorney, you can look and see at confirmation, are they where they need to be? And then usually your attorney will give you these guidelines of what to keep your eye out for as the case goes on. So, of course, your plan will say if your income goes up more than 10%, you got to increase your payment. You got to address that. You can't just say, oh, I make way more money right now than I did when I filed my plan, but I'm not going to pay any more into the case. That's not how it's supposed to be. So you want to make sure that you're doing these things, paying refunds, certain things that come into Chapter 13 cases quite often. But as those things are happening, they're a simple 1-sentence email to an attorney. And then the attorney can look at it and say, okay, yeah, don't worry about that. I've reviewed it and we're looking good. Or, yes, we need to talk about this. Let's talk options. And then I'll schedule a call in my office with the person to make sure that we chat it through. But yes, absolutely. It has a lot of flexibility. Trustees and judges, everybody understands that 3 to 5 years is a long time. And you want to make sure that you're adapting your case to what your situation looks like, and understanding that as long as you're paying what you have to pay, and then you're paying what the disposable income number shows, then you're doing what you should be doing. You just want to make sure you're adapting that as it goes along.
Like all good judges, they totally do understand it. And I think they also, though, understand when someone is putting their head in the sand intentionally, or even worse, deciding to hide some extra income or something like that. And that's where it seems like things can go really wrong really fast.
Yeah, no doubt about it. If you have extra income, and we do give this call as attorneys often, the trustee will review your taxes every year. And that's something that they will always do while you're in a case, partially because they want to make sure that your income didn't balloon, and they want to make sure you're paying your refunds that are required. Certain things have to be looked at by a trustee. And so they're going to require those taxes. And a lot of times as an attorney, when you do this long enough, if you've requested taxes a few times and the client doesn't give you the taxes, you start to get a little suspicious that maybe their income went drastically up. And now you need to deal with it, or the case has to dismiss. And those are the pitfalls with Chapter 13, that the trade-off is you're paying what you have to pay, and then you're paying what you can pay in that disposable income. And if that disposable income is, I'm going to pay all of the creditors, then that's what you need to do in order to get through the case. So Chapter 13 is a tricky kind of ball of Play-Doh that you can work with a lot to make it fit for the most part, but you also need to make sure that you're doing what you're required to do by the statute, or you won't get the end of the case like you want.
Yeah, we had another Facebook Live on a meeting of creditors in Chapter 7, which you had talked about, unless something really comes up, that meeting of creditors may be the last thing you have to worry about, and it just sort of goes on its own. But it sounds like this one doesn't do that. The 13 has to be looked at and possibly changed. It doesn't end with the hearing, the confirmation hearing.
Correct. We want to make sure we point out, though, that the Chapter 7 and the Chapter 13 trustee hearings, while they're a little bit different, they're kind of the same ball of wax. They're the same type of thing. This is the only chance the trustee and the creditors will get to talk with the actual client if you have an attorney. Everything else needs to be through the attorney. And that's the same in Chapter 13. The materials, everything gets submitted and reviewed by you and your attorney, but then filed with the court. And then the attorney is the one that goes back and forth and does a lot of that extra work. So the clients typically don't have to paddle the boat. They just need to make sure that they're helping to create the documents correctly. But there is definitely, in the Chapter 7, once you get through the hearing, there might be a couple of little things that you have to do, but you're almost done. In the 13, that's kind of the beginning, is when the judge signs off, and then it goes quiet, and it really isn't what I call autopilot. It's just in make your payments, get us our taxes every year, let us know if these 4 or 5 things happen, and then we can talk about them as the case goes on. And oftentimes, if somebody's making their normal Chapter 13 payment every month and doing what they should and sending taxes every year and setting aside their refunds so that we can discuss them, there's not a lot your attorney needs to do. And oftentimes, the case can go really smoothly as long as your income doesn't move at all. There's not a lot to talk about.
Yeah. We're just about out of time, but I want to ask, you had talked about you can dismiss the case, and then I think you said file a Chapter 7. Can the judge, just say, okay, you're not making this work, I'm going to convert it over to a Chapter 7?
People can try. Judge usually wouldn't do that. People can try to push that type of thing. But in Chapter 13, if you've told the truth, if everything is the normal case, you have an absolute right to dismiss your Chapter 13.
Got it.
So there's always that opportunity there. And then you can refile Chapter 7 down the road if you want, or whatever. You can even convert to a Chapter 7 from the Chapter 13. A lot of options. There's a lot of flexibility in there. But the key is, you can always take your cards off the table in Chapter 13 for the most part.
Wow. So before we close, if someone came in and said, okay, just one thing, if you don't remember much of anything else when you're in the middle of your 13, just remember this. What would it be?
In the middle of a third, so after the confirmation?
After the confirmation hearing.
Keep up with the case and try to review it individually every 6 months so that if your income has bumped up, if your taxes haven't been submitted, you're doing what your attorney is requesting you to do, because it's a long time. And if you get behind, then you've got catch up to do. And nobody wants catch up in Chapter 13. You want to stay with it. It's just like every other payment. Stay current and stay with it and keep those questions going. And I always say, if you're going to represent yourself, I got a lot of respect for you, but Chapter 13 is created to be a very complex area.
Yeah.
And having an attorney in your corner is very useful, especially because a lot of times you can pay most of those attorney's fees through the monthly trustee payment. So it allows you to pay it over time and spread it out, not make it such a big dollar amount. And if you find the right attorney that you want to work with, having that person in your corner for all of these different questions and then a lot more is really a very valuable thing. It's very much worth the money, I think, in this case.
I love it. Well, thank you for joining us. This was great. Great information.
Yep, no problem.
And thank you everyone else for joining us. If anyone has further questions, you can post it here. We can get you connected with Darin. And until next time, stay safe, stay happy, be well.